My name's Colleen Mary O&apos, and I'm a judge with 9 years' experience in the 11th District Court of Appeals, which is Lake, Geauga, Ashtabula, Trumbull, and Portage counties. I was born in East Cleveland here in Cuyahoga. My family, my mother, and still lives in our maternal home, which was in Lyndhurst. I was educated locally at Hawkins School and attended John Carroll University, so I'm Jesuit trained. After that, I went to Cleveland Marshall Law School, so I'm also an alumni of Cleveland Marshall. I basically worked my way up through the system, including having a job when I first got out of law school at the County Public Defenders, and that truly taught me the value of our legal system and the need for our legal system to be open and have open access, regardless of creed, color, or ability to pay. In other words, outcomes should not be determinative on the amount of money you have. I am a conservative judge, and by that I mean I follow the Constitution. And that seems to be a buzzword in a lot of circles. However, I learned it firsthand at the Public Defender's Office, because when you're defending folks who are accused of crimes, guilty or innocent, I had the ability to take someone who I believed was truly innocent and defend them. And we've gone to trial and they were acquitted. And without the Constitution, it was the only tools we have against the government. So I follow the Constitution as often as I can when it's raised. I have a long history of jurisprudence. I have many cases. I have a lot of experience. I also have some civil experience in the civil side. I was in-house litigation manager for national interstate companies. I also worked in claims and underwriting before I went to law school at Progressive Company, which is another Cuyahoga County-based East Side insurance company.
I just want to ask you, when you say that you follow the Constitution, I thought that actually judges had to follow the law, which is, perhaps it's 6 of one, half dozen of another, but I thought it was the Supreme Court generally that evaluated whether whether a law was not constitutional and not a trial judge or an appellate judge. Could you speak to that?
Absolutely. The Constitution, there's obviously, there's a series of laws that apply to the Constitution. Statutes must be constitutional. The Ohio Constitution applies, as well as the U.S. Constitution. Now, different issues are raised on appeal. We do deal with constitutional issues. Not often, however, and of course there is a presumption to try to resolve those on the statutory level and upon the assignments of error as they are assigned. Judges deal with constitutional issues as well. And when I speak in the Constitution, I also speak generally, like the Fourth Amendment. We often do things with search and seizure. In fact, most criminal cases, you have a motion to suppress, which includes following the Fourth Amendment and applying the Fourth Amendment to the Constitution. So as far as things, actually coming forward and being unconstitutional, it's more so as they are applied. Correct?
I guess what I'm asking is, do you feel it's your role to evaluate whether the Constitution applies in a greater measure than law and precedent?
Oh, well, I think it would be the equivalent of the Constitution being a lodestar. So everything goes up against the Constitution. If we don't have to get there, it's always a good thing. If there's a statutory law that applies, we would of course apply that first. Is that what you're asking?
That is what I'm asking.
Okay, that is correct. That is the proper application.
I'm from a different part of the state, but I'm a judge on the Court of Appeals in Cincinnati. I grew up in the Cincinnati area, went to St. Xavier High School, got a partial financial package to Harvard, had to pay the rest of the way through as a janitor on dorm crew, cleaning bathrooms and picking up trash. It helped get me into Harvard Law School, and from there I had a clerkship with a federal judge in the Cincinnati area. I worked in Texas for a while. My wife's from Texas, and we lived there for a couple of years, and then moved back to the Cincinnati area. I was with the law firm of Keating, Meath, and Cleveland for over 25 years. I traveled all through the country trying cases, about 1.1 million frequent flyer points at its height. Any trials in LA and oral arguments in New York and everything in between. In 2004, I had a case that was filed the Thursday before the Bush-Kerry election that I was asked to represent the Bush side, and it went to the Supreme Court and got a decision my way at 5:27 a.m. Election morning from Justice John Paul Stevens. And that changed my life, because then I went to go vote soon thereafter, because I was afraid if I went to sleep I'd miss the election. I'd been up for several days, and I realized I was voting in the presidential election that I had just contested in the U.S. District Court, the Sixth Circuit, and the U.S. Supreme Court, all in the 24 hours before I was voting, and the system worked. The legal
What was the case that you...
It was there was a new law after the 2000 election. Mm-hmm. The HAVA law, Help America Vote Act, required all the states to adopt some new laws. And this was a new law involving voting observers, which are the people, if you don't know, stand behind the voting judges. And the Republicans had used it and named voting observers to any precinct that had voted for Gore, for Vice President Gore, for 60% or more. And the Democrats said, well, it was vague, the law's vague, can't be enforced, and it was to intimidate African-American voters. Actually, the decision, we started out on Thursday. It was argued Thursday, or tried. I mean, originally it was going to be a half-hour TRO hearing on the phone. But the judge said, no, we're going to have fact witnesses and experts. So Thursday at lunch.
This is now at the appellate level.
No.
This is at the Supreme Court level.
No, it went to, this is at the trial court. You're the Thursday before the election.
You're in a trial
Court. And it goes all Friday, Saturday exchange discovery, Sunday morning exchange briefs, Sunday evening we're in federal court. Again, I've never been in a court on a Sunday before or after. At 2 in the morning, Judge Dlott issued an injunction, although we won on the racial issue because there was no evidence. They had just picked any precinct which had gotten 60% for Gore. But she said the law was vague. And so immediately we asked her to stay her injunction. She denied that 8, 9 o'clock Monday morning. We asked for an immediate appeal with the Sixth Circuit, got them to accept the case. Briefing done by 6 o'clock that night. I sent my team home.
Now we're talking Monday.
Monday, the night before the election. Oh, yes. And then about 12:30 a.m., I sent the team home because they hadn't slept either. And I was the person in charge, so I had to stay. And 12:30 a.m., the Sixth Circuit went 2-1 my way, staying the injunction. And I thought I could go home and get some sleep. But the Kerry campaign appealed to the U.S. Supreme Court. Justice John Paul Stevens gave them a briefing schedule. I think theirs was due at 2 and ours at 3 or 4 a.m. or something. Got it done. I had to call my team back in. They weren't happy to hear my voice at midnight or 1 in the morning. At 5:27 a.m., I still have the original facts, because my cases before that no one would hear about or know about. But to me, it was a big deal, and it changed my life about why judges are important. And that's when I became a judge and I was president of the bar, I'd go around to the Rotary clubs and the Kiwanis and I'd give speeches, and I'd talk about why each judge matters. I'd say, everybody in the room who knows somebody who's divorced, raise their hand, and people look around. I'd say, come on, raise your hand, everybody knows somebody. And the same question about people being adopted or adopting a child, or hear something in the paper about somebody being sentenced to prison or to death, or a law declared unconstitutional. I'd say, now, you got to understand, not the governor, not the president, not the Congress, not the legislature can do any of those things I just mentioned. Only a judge can. So each judge matters in people's lives in a big way. Now I want to ask you, can you remember who you voted for or against in the last couple elections for judges? And everybody's going, they don't know. Because judges to me matter, and that day had a big impact on me.
What did the Justice rule?
He upheld staying the injunction.
Yeah,
So I called these people in Columbus, said you can send your people in.
To the observers.
Yeah. It never. The final decision never made the media. The Sixth Circuit decision did, because I went home to go to vote, and I was kind of washing my face and I was listening. And the Today Show had the 2-1 decision,
Right.
but the media.
In today's 24/7.
It would have caught it up.
It would have.
Right.
But anyway, I interrupted you.
No, and then from there, I decided I'd run for judge someday, and no one would run in 10 for a judgeship against a big name in Cincinnati, Mallory, huge. Nobody from my party had ever defeated a Mallory in 30 or 40 years or something. So I said I'd run, and I won. And in 11, and because in 09, I had promised some friends who'd come to me and said, "Would you run for state bar president?" In 10 and 11. because you did a good job when you were Cincinnati Bar President. I had promised I'd do that before the judge thing came up. So I did that, ran statewide for that. And then in 12, I had to run for a full term for the judicial position, and I held the seat even though Mr. Obama carried the county by a far margin. And after that, a bunch of people, especially lawyers, came to me and said, would you consider running statewide?
Right.
So that's the story.
Although your candidate sheet does note that you ran for Cincinnati City
That was,
Council in 07.
that I did, and that was at the county party's request. I was president of what's called in Cincinnati, they have about 50 neighborhood councils, and I was the only Republican that I know of that was president of one in Pleasant Ridge, which is kind of a racially mixed and politically mixed neighborhood. And they said, would you please run? They needed a fifth person to run. I ran. I didn't think I had much chance. You had to finish top 9 out of 23, and I finished 12th, I think, or 13th. So it's actually, but it wasn't. After the 04 incident, I wanted to be a judge. So I don't know what else to tell you.
Okay. Well, I suppose the next question is, how would you see yourselves fitting in on the Ohio Supreme Court? What would you, bring to that role that is different than what you've done in your lower court experience? Judge Fischer.
You want me to start? Yes. I would bring a different perspective. I think I'd fit in well. I think I know everybody on the court. Collegiality, since I became an appellate judge, I've lived by an article, if you want to check it out. It's by Judge Harry Edwards, who was the chief judge of the D.C. Circuit Court, and he talks about how to be a collegial appellate judge. And I've followed that, not word for word, but in general. And I add collegiality. I also add an ability to figure things out and how to make them move faster. On the Court of Appeals in Cincinnati, when I got there, they were averaging 40, 45 days to get from oral argument to an opinion out, which actually is pretty good. Mm-hmm. I'm averaging less than 24 days. And for 5 consecutive years on December 31st, I've had no cases pending on my docket because I practiced for so long, and I don't know how to describe this, but you would get a call from clients every week. Have you heard from the appellate court? And it just wasn't fair. I mean, I'll admit, to us, it's one of hundreds of cases a year. But to those people, it's their whole life. They could be in jail or out of jail. They could win $1 million. They could lose. They could go bankrupt. It matters. It really matters. And so justice delayed in my mind really is justice denied. And thus I worked a couple Christmas Eves to make sure I did that, to clean my docket for the end of the year and get those things out. I also have a perspective on, as bar president, I would appoint people to these rules committees that, talk about just changes in the rules.
Were you bar president at the same time you were
a judge? I was one of only two, since John Petzold from Dayton.
I know the name.
Yeah, one of two since, I don't know if it's the Vietnam War or Korea sometime, as far back as the records went. But you'd appoint people to commissions and suggestions of people, and they'd come back talking about, these are good ideas, but people aren't taking into perspective the cost, the benefit to the litigant or to the lawyers at the time. And so I would urge, if I get on the court, I'm going to use a bully pulpit, that every time they propose a true substantive change in the rule, that it included what I would call an impact statement of the cost and benefit in time and money that it's going to cost the parties, on average, for that rule change to be implemented. Because the public should know that before they give their comments. And I think the judges and the lawyers should know too. Because we're in a world where things are moving faster and faster. And if we're adding rules that slow it down, at least if we're doing that, we should go in it with our eyes open. The third area is I have the ability to save money. My dad always taught me that if it's somebody else's money, you have to be more careful than with your own. That's the way he would put it. And when I was bar president, I was supposed to have a budget and return surplus of $100,000. I returned over $1 million. The staff gave me a hat that says El Cheapo on it. But I've done the same without touching the quality of our decisions in the Court of Appeals in Cincinnati. We had 15 back office staff people when I started. We're down to 10. What I got our administrator to do is cross-teach training so that when somebody was ill, people could fill in. So we've cut the budget, according to the administrator, about $200,000 to $250,000 in those 5 years, a decrease of 33%, and yet we're actually getting stuff out faster. So I would bring those attitudes, I think, to the court. And there's one other I would bring. The U.S. Supreme Court permits a writ of certiorari to be accepted by 4 votes out of 9.
We've been reading a lot about that lately.
Yes, you have. I'm sure you have. You still need 4 out of 8.
Exactly.
But the Ohio Supreme Court demands 4 out of 7. So the court theoretically could box up an issue. A 4-member majority could box up an issue and prevent it from being heard. And so I would propose that every 2 years terms, because the judges, there's usually 1, 2 different judges every couple of years. 2-year term, every justice gets 1 extra chit or vote, or I don't know what you want to call it, so that if the vote was 4-3, once every 2 years, they can use their extra vote and get it, say that's the 4th vote, and get it in front of the court. And somebody said, well, it's going to create all this more business for them. It would create 7 more cases over 2 years. It's 3.5 cases a year. I think we as justices can afford to do that for the public and to act as a valve to prevent issues from being cemented. Or I don't know how to block off.
Yeah.
And I want the future of the court's very important.
Okay. Just one quick question
Sure.
before we move on to Judge O'Toole. How would you characterize the First District Appellate Court versus other appellate courts in the state? Do you have a different caseload, a different type of case? Is there anything that distinguishes it from, say, the Cleveland Appellate Court or the
We have half the number of judges of the Cuyahoga Court of Appeals.
Yeah.
I think we have about half the cases.
Okay.
So it's pretty proportional.
So how many judges are there?
6. And there's 12 up here. I think there's 8 in Franklin County, and then the others have 4 or 5 from the other districts.
In your district, there are
5.
5. Okay.
Yes.
All right. So the same question to you. What would you bring to on this?
Well, although I very much agree with Judge Fischer's position on court efficiency and effectiveness, we've pretty much streamlined that in our own court several years ago during my first term. I'm sorry. But the area that I think is most important in the Supreme Court is forward-lookingness, vision, understanding the paradigm shift brought about by the internet, brought about by digital access, the flattening of the knowledge curve, which basically means things need to be done in real time, people need to be more responded to. And so I think the present court is more concerned about controlling information, and I don't think that a lot of them realize that ship has sailed. We no longer can control or disseminate information because information is being disseminated everywhere. So we need to start looking in that context for things like judicial transparency, public records, access to justice initiatives. The other area that I really want to work on that I don't think they're working on much is the access to justice initiatives developing pro se representation. In other words, we have huge crisis right now with people not being able to afford lawyers. And the fact that if you have a lawyer, your outcome in your court case is radically different than somebody who does have a lawyer. Okay, that in of itself is creating a two-tiered form of justice. Technology is available whereby we can have drop-down menus. We can actually technologically overlay our systems so that people can actually get a just result by representing them pro se. Now, I'm not talking very complex commercial litigation. I am a supporter and or a fan of the commercial docket. I understand that experiment is failing here in Northeast Ohio.
We've had just a bit of a disagreement with the Ohio Supreme Court about how that is organized.
Well, and that's a really cool point. I think the experiment is great. The key is now we have to get in and do the hard work and look at a best practice and say, okay, we did this. Why did it fail? And how can we still, I mean, everybody agrees it's a good thing. The problem was it was selecting out certain judges and again, creating a two-tier class of justice. And so we can look at these models. I mean, we need to start looking at things with a vision and a lens toward all of our old paradigms in regard to administration may no longer apply. And some will apply, no doubt some will apply. But we can no longer keep doing things the way we've been doing them. And I think that's been my issue with the Supreme Court, as well as I'm pretty vocal, even in my dissents in my court, is that I think I'm representing a future or forward-looking, and they are still looking toward the past. Another example, we're never going to fill the supply of lawyers, right? There's a huge deficit with folks who need lawyers. We're always sending more money to legal aid, a very worthy cause. But why aren't we putting that money? In fact, I just did a public comment. Why aren't we sending all those tax dollars to court so they can develop, again, a pro se access point and we can start monitoring it? Everything about justice. In fact, when I was in an interview with another organization, you're all familiar with Moneyball, right, in baseball, and how they started using statistics and how suddenly we need to look at that through the lens of the justice system, because it will eventually overtake us. People need to feel we're relevant. They need to be engaged. And although I applaud Maureen O'Connor and everyone who went into, the Justice Counts website, okay, I don't know how many people are ever going to look at that website. We no longer can tell them it's important to them. They have to see the need. And so I think being a public servant, as well as a judge, I think our role is to open up the justice system, make people understand that we're fulfilling our core competencies and that we are actually filling their needs of a justice system that works and that's fair and that's equitable and outcomes are consistent, outcomes are cost effective, right? And I'm the proponent. In fact, I'm working on an article on the sustainable justice system, looking at it like all other systems, right? Putting the incentives in place, and especially in the criminal. I mean, look at what we're looking at in the criminal outcomes, right? People who are now lifelong criminals and they can never get back on track, right? I mean, that's a giant waste of our system and our resources. Or not looking at the data to see how many of these people are being funneled through again and again and again, and it's still not working. So, although I might ruffle feathers on occasion, and that has been my reputation, is challenging authority or challenging maybe the way we always do things, it has been my nature, not only with the Public Defender's Office or with the companies that I work for, that I have a seminal influence by being a minority voice. Our court in the 11th Appellate District, as you're going to become aware, because my colleague is also running for Supreme Court, is a diverse court in its opinions. But we're pretty much always on the forefront of coming up with new or different ideas or thoughts. And so that's how I think I could do value added.
Okay. So you're in an unusual position, Judge Toole, running for the court that basically rebuked you in your last campaign for how you handled that campaign, where you appeared to be portraying yourself as the incumbent when you were not so, and they actually disciplined you over that. I wonder if you could address yourself to that issue.
Absolutely. It was obviously brought by my opponent, or her camp, not her personally, and that was well in the record. There were 12 assignments originally that came, and they said, well, you can just plea to this and do it. And I'm like, no, I have a case, right? The O'Neill case was clearly, I felt, on all fours with my position. And, of course, my colleague here was a dissenter in that. He was also, by the way, appointed to my Supreme Court case as well. Kind of interesting there. Numerically improbable, but nonetheless. And so what happened was I fought my First Amendment rights. I went all the way up. And I think if you look at Justice Pfeiffer's concurring opinion, it pretty much sums up my position very clearly. But, in fact, I even brought it with me. Oh, it has stuff on it, though. This is the alleged name tag that was found to be a violation, but it's an old one, so I don't wear it anymore. But and I also wore a pink underneath, right? And so to me, it was about the government telling me what I can say. I never meant to mislead anyone, obviously, but the voters themselves were aware of it because it was front and center in my election, and they still elected me. And so the idea of being called by your honorary title, I didn't think was necessarily an offense or something that should be disciplined, and I think it's more politics, not ethics.
Although on that button it clearly says Judge, 11th District Court of Appeals, which you were not at the time. You were the previous judge.
Well, it says underneath, it says judge, because that's the position I was running for. And also I had a pink button that said for. But either way, the other interesting point about that is they also held one of their own rules unconstitutional. So yes, I was cited for a singular button, but the Supreme Court held one of its own rules unconstitutional, which is also a little odd in that they had unconstitutional rules to begin with. And it really brings a point as to our judiciary in these ethics opinions, being judge, being jury, being prosecutor, right? And it goes to the point of conflict, and it goes to the point of a system which is very closed. In addition, I mean, just as a segue to that, the Ohio Bar Association, where my opponent was, president while he was a judge, the Ohio Bar Association is the largest legal lobby in the state. They have 3 full-time paid lobbyists that do nothing but lobby the judiciary. They are on every Supreme Court panel, which is the other reason why or not every, I'm not talking about panels, but like your commissions. They have designated positions on most of those that get appointed by the Ohio Bar, which is the other reason why I did not participate in the Ohio Bar poll.
I was going to ask you about that because you're one of 2 candidates who is not recommended running for the Ohio Supreme Court. You did not take part in that?
No, I did not.
Process.
Yeah, I can let you know what happened. We decided very early on, and I've always pretty much been like this on bar associations, because they are legal lobbies, because they represent an interest of the largest stakeholders in the justice system, and they advocate for the benefit of their members and lawyers. They don't necessarily advocate or represent average litigants and people who I feel we serve. So what we requested of them is we requested that their interviews be transparent. I did this for Judge for Yourself, as well as I did for the Ohio Bar. And I said, you are stakeholders in our system. I am a servant leader, and I will respond to your questions because I think I should answer all questions, being an elected public official, but I want this made transparent in the interview. They have a high level of secrecy, and their recommendations, by a lot of people's standards, no one knows why they come out the way they come out.
Although I looked at, their release about this, they're very clear about the process by which they arrive at their recommendations and, what, if fewer than 60% of the members, say not recommended, that's...
Well, what we did is we asked for them to be transparent. We asked to video record and post on our website any interviews that we had before the Bar Association. And they refused. So we said, we're not going to participate in the oral piece. We will submit all the questions you want. We did that. And then they voted to not recommend us, even though last time they recommended Sharon Kennedy didn't participate. So they rated her differently when she did not participate 2 years earlier. So.
Okay, I might have missed something. Did you say you actually did participate?
Well, we sent in the survey because we answer all surveys. I don't care if you're, citizens for whatever.
You sent in the survey but did not participate in it.
Right. We sent them a letter asking to make it transparent and asked them to allow us to video record, or they could video record, and we would post it on our website, or they could post it on their website. The Judge for Yourself thought it was a good idea, but they couldn't amend their bylaws quickly enough. But they are looking at it, and that's why they gave us a not participate, because that was their option under their bylaws. The Ohio Bar, I don't know if it has any other options, but it must. But it flatly refused. And there's a huge perception on the part of the population that there is some kind of coercion going on between judges and lawyers, and that somehow the lawyers fix the system for the benefit of themselves or the people they're representing. And so my goal in representing the judiciary, as well as being a public servant, is to open the whole thing up to transparency, which is consistent with, what I'm running on and why I'm running. I think this closeness and the lack of transparency is a threat to our justice system. I think it's a threat to our core competencies, which are the administration of justice and the people's perception of equity, and that we do what we're supposed to be doing.
And just to clarify, I think I misspoke before. It says here, candidates who receive favorable evaluations from fewer than 60% are then not recommended. so you have to, get at least, 6 out of 10 participants, favorable recommendation to
Right.
use that bar.
So consistently with that, then Sharon Kennedy, I don't understand how she was not, she was listed not participate.
Well,
But maybe she got 6 out of 10 and then they said not participate? I don't know. I don't know either.
I can't respond to that.
But it goes to the piece that this is pretty political to begin with. Thanks.
Help me understand. I mean, I understand that you were, that you still won your 11th District Court of Appeals race despite the whole fuss over the
Name
that.
tag.
But I think the people in Ohio, the rest of Ohio who may not know you, how do you explain that by wearing that little sign? It seems misleading. It seems like you are already the judge, and therefore I should put you back in your spot where you belong. Didn't you see that as misleading to people?
No, I actually did not. I thought I could use my honorary title as most people use their honorary title. President Clinton, there are many judges that go by judge out there when they're retired and they're not presently sitting on the bench. It is a fairly common way. Most people called me judge because I was just recently off the bench. And I don't think it necessarily was in any way misleading, nor was that in my intent.
But that's a situation where, it's a little bit different. You're going to the supermarket and, people say, oh, hi, judge, as opposed to you're appearing on panels or you're getting out the vote, knocking on doors or whatever you're doing and people see.
Right. Well, and that's the cool thing about the First Amendment, right? The answer to that is more speech, not less. So people have judged whether or not that was misleading. I know what the Supreme Court says. I know what the folks on the committees said, and I understand that. But I disagree with that position. And furthermore, the citizens of Ohio had held that it was not misleading and that it was a customary and usual use of the term. And that had been resoundingly the feedback that we had received.
Another point on this, though, is you have a last name that some might consider ballot friendly. Are you kind of riding along on that rather than seeking these Bar Association endorsements or ratings?
No, because I would very much like to participate in the Bar Association ratings, and I offered that to them, and all that I requested is that they make it transparent so that everybody could see how I answered the questions. And I think that's consistent. I don't think I'm writing, in lieu of. I mean, I know that it is an issue, right, because especially Northeast Ohio, we do have a lot of judges with Irish surnames. And when we crunched the numbers on that and looked at why, it's because Irish is the largest ethnic group in Ohio. More people claim Irish heritage or an affinity with someone who is Irish. And also,
Actually, I think it's German, but that's
no, I think German's second. But we can check. When I researched it, that's what I was told when I had people research it. But I think German is second. But it could be. I could be wrong. They could have overtaken it since the last time I researched it. And the other thing is that Irish historically have gone into areas of service, government service, police, fire, prosecutors. That's a kind of a thing that I know many in my family do, as well as many other Irish families do. So it's a natural feeding ground to a judicial office.
we have
Sure, go ahead.
not let Judge Fischer
It's okay.
for a while. As somebody who was a past president of the Ohio
Yes.
State Bar Association, perhaps you could speak to Judge O'Toole's concerns that it's not a fair process in its ratings.
It's actually the fairest process you can get. The people that are put on the commission are past members of the Board of Governors or Board of Trustees. It's not by any other mechanism. So if they were elected in their 18 districts, they're on it. Unless, for example, people that were close friends of mine that were from the first district of Cincinnati, if they knew me, they had to, and so they'd keep going back till they got people that didn't know you. And so that is a very fair way to do it. It's from all over the state, and then there's also appointments, additional appointments. When I was bar president, I think I appointed either one or two additional people to make sure that there's minority representation and other geographical diversity and things like that. So it's a broad spectrum of the bar. The way they vote, I don't know, because there's two things they don't let you do. There's your bar president, they don't let you in the room, and if you're a judge, they don't let you in the room. So I was knocked out twice. But where else? There's part of the ethics, it's not in the ethical rules, but in the comments, where lawyers are supposed to make an effort to educate the public on the court system and judges and things. And this is the way the bar does it. Should it be 65% or 55? I don't know. I'm not that involved. But when I read the bylaws, it said if you don't interview, we may evaluate you anyway. And I presume that's what they did. And right above that is the 6 factors: legal ability, writing ability, all those factors. And all I did is check them off and make sure I had all of them. And I think that's what helped me get highly recommended.
I did have one more follow-up, though, I'm sorry.
Yeah.
And that is, in the sort of, coincidences that happen in life, it appears you served on the panel that evaluated Judge O'Toole's swearing of the badge, and I believe there was also a sign involved.
Yeah.
Could you speak to her contention that this was a First Amendment issue and she shouldn't have been dinged on it?
The First Amendment, I think the opinion by Justice Lansinger is absolutely correct. The wording of one of the rules was slightly incorrect and had to be changed, okay? But if you look at paragraphs, I think it's 45 or to 55 or so of the opinion, it talks about the whole idea that the argument that a judge can go around lying or misrepresenting isn't good, and it's not ethical. I mean, from the legislative and executive branch, there are ethics we have to follow also as judges when we're running, but that's statutory. We also have to follow the higher ethics of a lawyer and a judge. So we have different values that we have to meet. And both the Ohio Supreme Court and the U.S. Supreme Court, as recently as last term, you can look up a case called Florida versus Williams-Yulee, Y-U-L-E-E, said that judges are different. It even says elected judges are not politicians. I think that's almost word for word. But it's because you have a different value set that you have to meet and reach. And you don't have to become a judge. Lots of people give up their First Amendment rights to take different positions. Doctors can't spew out private information. They would lose their license. There are values that we have. Not that transparency is a good thing, but we do have other values. You have attorney-client privilege. Lots of people give up First Amendment rights, and it's to do some other value. Doctors, priests, ministers, so you got to keep it in perspective, and it's very important that we remember that. Just because you have a right doesn't mean it has to be used. And what has happened if right now there is a Sixth Circuit case, I think recently, within the last week or two, it says legislators and executive branch people can lie.
Yes, Susan B. Anthony.
And it's the bigger argument. But the U.S. Supreme Court, I'm telling you, as recently as last year, said that the rules are different for judges. And that's what I believe it should be, because it leads to a slippery slope if you go in the other direction. Because if you're allowed to say whatever you want, why can't you say, I will always rule in favor of person X or person Y? Because that's freedom of speech. And you can't have judges prejudging cases, because otherwise it's not fair.
All right, can I address that? I think that's a really interesting perspective, because judges need to be able to say what they think about things. All judges have bias. There's some judges that put everybody in jail. Some judges don't put everybody in jail. It depends on their perspective and how they interpret the law. Okay, and working the Justice Center, everybody knows, right? Some are tougher, some aren't. Some get probation. So the question is why? And this goes to the issue.
I think we're not talking about broader speech, but rather about lying.
Well, right, and the position was that I relied on a case, and I was not lying, and I take umbrage with that fact. I went in a position. I truly feel that if I am politically targeted in a campaign for that purpose, I don't think it's that at all. And I relied on a prevailing case, the O'Neill case, that was subsequently discarded. And you should read the briefs. So I had a Supreme Court precedent I relied on. I just didn't wake up and do this. We actually looked at it. I consulted attorneys and everything going into it.
Okay, but if I am understanding this discussion, what you're saying is that there was a precedent saying you could wear such a badge and it's okay, as opposed to this idea that was determined, this was intentionally misleading and therefore not allowed?
The question is when can you use the word judge around your name? That's the seminal question. And that was litigated in the O'Neill decision. And also, the issue, they rewrote all of the rules at that point. They rewrote the rules of superintendents on top of finding their own rule unconstitutional. So the change was certainly needed, and I believe that I was correct, or at least at the very least those rules were vague because they changed them all after the fact. Thank you.
And I'm sorry, you're still challenging those rules, right? There was a story that said you have a case pending in the U.S. District Court.
Right, that's the issue on fundraising guidelines.
Oh, it's on fundraising.
And that's basically the same thing, that judges, people are best served when judges can get their message out. Presently, judges can't get their message out because of how restrictive the fundraising guidelines are. And the question is whether it's narrowly tailored to the government interest of we don't want judges out raising money all the time. So, I mean, the actual practical outcome is that judges have to raise a lot of money in a short period of time, so it makes them, more inclined to, to give favor, I would think. So we're looking at those. That's what's being litigated now.
First of all, I just didn't hear one thing Judge Fischer said, and just a biographical fact. Was the judge you defeated one of Judge Mallory?
Yes.
Okay.
Bill Mallory Sr. was his father.
I know the family. I mean, I know of them.
His brother was the mayor at the time.
The family has got a long history on the public payroll. Worthy office holders.
Sure.
This is a question for each of you, starting with Judge Fischer. As each of you know far better than we lay people do, the state constitution, the Bill of Rights of Ohio, gives a person, a litigant, it says man, but they mean litigant, for every wrong done him or her and his lands, goods, power, and so forth. Basically, the right of tort stuff. Judge Fisher worked for a very successful large corporate law firm, one of the 2 or 3 biggest in the state, in Cincinnati. And Judge O'Toole said at the beginning that she considers herself a conservative philosophically. So my question to each of you, starting with Judge Fisher, is, and this is very general, I realize, from your perspective as appellate judges and learned in the law, is the state of litigation or jurisprudence in Ohio right now pretty evenly balanced between personal injury litigants and personal injury defenses, or does there need to be some rebalancing of the opportunities each side has to defend or win damages in personal injury cases?
Right now, I would say it's pretty balanced. I just had a case, you can check it out, Weta, I think, W-H-E-T-A, Judge Weta, or Dr. Weta, something like that, where it was a Tort Reform Act issue. And the plaintiff was arguing, I don't know if you know how it works, but it was $1 million of non-economic damage. And the plaintiff was supposedly 30% at fault. So $700,000 gets knocked down to, but then there's a maximum that the legislature's put in of $500,000, and that's what the trial judge entered, and that's what we affirmed. Then the doctor cross-appealed and saying, no, you put the $500,000 max first, then you deduct the 30%, so it's only $350,000 the person was supposed to. But that's not the way the law reads. The law reads the opposite, and so we affirmed the trial judge on both. And I wrote the opinion because that's the wording of the statute. And my brother's deceased now, who's a plaintiff's lawyer, okay? And he would say that the balance has shifted too much to the defense. My other brother, who's a lawyer, 3 of us testified at a trial when I was in the 8th grade. No lawyers in the family before. My other brother, who works in-house at a insurance and financial company, says the balance still leans too far to the plaintiffs. So you know what that means to me? Balance pretty close to somewhere in the middle. And some people would say it leans too far one way or leans too far the other. But that means that probably it's close. But it's not really in that issue. You were talking about the tort issue. It's not really our call. As long as the law is constitutional, then I have to apply the law as written, which is what we did in that case, word for word. And that's the way it should be. In my mind, the ship of state is a sailboat, and the wind is the people, and the mast and the jib are the two houses of the legislature, and that moves the boat. And then there's a rudder and tiller, and that's the governor or the president, and they're kind of directing the boat, even though the wind's blowing it. But then there's the centerboard, which keeps the boat from turning over. And in fact, if you're going this far, you can actually hold on the straps and stand on the centerboard and push it back in. And that's what the Constitution and the courts are for. So when they go too far one way or the other, that's where we step in. But as long as they're within this reasonable realm, then we uphold the law, even though personally we might go one way or the other. As long as it's within that highway, okay, and they don't go off the highway in either direction, then it's the right balance.
I want to follow up on one thing, and before
Okay.
I ask your colleague,
Okay.
to ask the answer to the same question. I couldn't agree more with you, and you two very learned people know the law, and I don't, but it's certainly the case in appellate courts, especially the state Supreme Court, sometimes in effect establishes causes of action.
Creates, yes.
It creates a cause of action. So the legislature does in fact decree certain things one way or the other, but there's also, judges they're on an autopilot, especially in the appellate level.
There
Autopilot.
are
not.
Okay.
Not on autopilot. That's the context of my question as well.
Okay.
But we think that because a number of times workers' compensation cases do reach the state Supreme Court because of the way our jurisdiction
The way
is
it's
set up,
set
I
up,
think.
sure.
And that's one of the issues that the ordinary person, the ordinary blue-collar person in Northeast Ohio or any other place would be concerned about jurisprudential approaches to those kinds of cases.
Right. Well, that's the intentional tort issue, and that is a whole other issue. The court, I believe, has ruled that new law, the new version, making it, I forget the exact wording, but it changed it from substantial certainty, recklessness, to a higher level to create the tort, has been ruled constitutional. And as an appellate judge, I'm constrained unless I find some wording of the state constitution that takes that away. And I haven't seen that yet, although the issue hasn't come to me quite yet.
Just wanted to judge
Yeah.
about this balance of plaintiffs and injured parties, and is our jurisprudence fairly balanced in the state, or does it need recalibration?
Legislatively, obviously, again, I concur with Judge Fischer, we have to follow the law. But there may, and we've not seen it yet come before us that way, but I think it's pretty much like an economics issue, a bigger economics issue, and it needs to be looked at systemically.
Right.
And the reason being is that our system of capitalism and our system of government always functions best when it's well balanced. And so the question is if you're looking at somebody who commits a bad act, whatever the bad act is, right? They were the person who was reckless or in some cases criminal. They need to take primary responsibility of it. Now, what we have with our insurance system is you create a third-party payer system, right? Where I do something, I run into someone in a car, and then my insurance company pays for it, right?
Right.
So the key there is we need to make sure that we keep the insurance company that insured the tortfeasor responsible for the actual damages on the other side, and not dissipate that through a series of legislative manipulations. And because what happens then, obviously, especially in areas of large tort, then you have the government picking up the tab, right? When the insurance company denies the claim and you relieve the person who originally did the negligent or tortious action, then damages, let's say they don't have insurance or something else, they're now asking for government benefits on the backside. Somebody has to pick up those losses somewhere. So as a system, how are we going to allocate the losses? How are we going to make reparations in an area when there are several people that could be held potentially responsible? And by deflecting it through the insurance code and the tort law, that's exactly what happens. And I think you see some of that now, especially with the insurance caps, right, where people are severely, traumatically, mentally injured, but it's technically not, a hospital bill. But yet they can't get above the cap, but yet they're psychologically ruined. You know what I mean? And for whatever reason.
I do. That's my follow-up either for both, although you may choose not to answer this.
That's okay.
I'm not sure
But-
it's pending any place or not.
But the big issue is, too, at some point, I think, we're going to run up against a due process or some type of issue with the statute whereby it so denies any kind of recovery. It subverts our entire area of tort law, right? When you can never get recovery from the person who did the injury because there's just so many, you're going to have a due process issue or some other issue that you're going to at some point come up against.
we'll return to you and then go to Judge Fischer.
Sure.
Do you think that it's good public policy to have caps on damages, economic damages and money damage, just on money recovered? I don't know the legalese.
The issue with caps, and here's the other side of the economic argument. I've taken a lot of classes on economics because my background was history, political sci. So I'm not an economics person per se. So I've really had to learn that area of the law, and not only as a lawyer but a judge. So I've taken a lot of CLE on that area. And so what it is companies need to know, insurance companies, because I work for an insurance company, so they need to know what their potential outlay is in order to properly price their product. So when if you don't have a cap somewhere, then the question is how can they price the risk? And if they can't price the risk, they don't write the insurance, right? It was the malpractice crisis of a few years ago. They couldn't figure out what it was going to cost them, so they have to basically overcharge the doctors because they can't assess what the outcome of the claim will be because you don't have a cap, right? And so if you're trying to have an insurance company that adequately insures all of the insureds, and you get a multi-million-dollar loss, that's right, because it might have been the loss, but you didn't price for that loss. So it becomes very difficult to operate the business of insurance if you don't have some kind of finite limit on what you have to pay out. Now that's that side of it, right? And then on the other side of it, of course, is then who pays if you have a multi-million-dollar loss. So the key is caps. I mean, we have caps. I have to uphold caps. It's the law of the land, and I will do so religiously until it's otherwise changed. But I think as an economics issue, we really have to start looking at, how we assess that. It can't be fixed in time, right? You can't say $500,000 10 years ago. I mean, obviously that money is not worth the same today, correct? So when those are static in time, then you run into problems that I think we're running into now, where the caps actually aren't covering the losses in some situations.
Thank you. Judge Fischer?
Were you asking about economic or non-economic damages?
Well, actually, I was not going to get into that distinction because I understand it is a distinction. I'm not minimizing it, but I'm trying to think of it as a layperson would think of it.
Okay. The economic damages, the out-of-pockets, there's very few caps on, okay, these days. The non-economic, there are caps,
yes.
Clearly. And that is the pricing issue with the insurance companies and all that you run into. Especially actuarial tables and stuff, you can't price that, and so it's hard to lay off that even into the reinsurance companies. So I understand Judge O'Toole's argument about maybe indexing or something, the amount, but courts aren't equipped to do that. Okay, the one thing courts are good at is resolving disputes between two sides. But taking in all the testimony from the different insurance companies, the different parties involved in this issue, that's a legislative thing. And that's where the legislature should come in and deal with the issue. And because the two parties generally don't care. They want to win. They're not going to put on all the evidence from all the people who are against them or for them. And that's why to me, it's this issue of the amount of the caps is a legislative issue until if you can actually get to a point where it is a due process issue, but I don't think it's there yet. But I had the same discussion with my friends who are OAJ plaintiffs' lawyers, and I keep saying the courts are ill-constrained to take in that evidence unless you have a lawsuit declaring the whole thing unconstitutional. Go to the legislature and try to, if you want to get the amounts raised. That's where the issue is.
Well, the reason I ask is because, of course, I believe the caps on non-economic damages are relatively recent in Ohio law.
About 10 years.
Recently, yes.
Yeah, 10 years.
And that's so before that we did not have them. And I'm not being sarcastic when I say I don't know that it broke the backs of many insurers, although maybe as often I don't know about a lot of things. And that's my question. But again, you're right, it is a legislative question.
Well, it goes in the opposite direction, too. I used to do a lot of antitrust law.
Right.
You got treble damages by law as a penalty. And so the people that insure large companies that have large percentages of the market take that into account, that if they pay, they may have to pay treble. And so if you can say you can give extra damages to somebody, add to them, then you probably have the same right to say we can cap some others. Now, if you throw that out, different issue. But those have been upheld too.
You may also, as an idea, they may also be able to do some level of fixed punitive damages.
Yes, that's a good point. Yes, ma'am.
Do you know what I'm saying? Like another idea. I mean, and of course, this is all legislative.
Right.
But at some point, as a justice, our core competency people come to us. They're not getting compensated. By the time they're done with their 30% attorney's fees, by the time they're done paying the hospital the full rate, not what the hospital actually paid the third-party carrier, these people are walking out with very, very little, and they're severely damaged. They're the ones who are actually walking away with the bad leg or the horrible injury. And so the question is that really a judicial function? No. Does it go to our core competency and trust in the courts when people come to us that there's going to be a just result somehow, that we're going to resolve it in a fair and equitable way? And that's where you run up against, this exact interpretation of the law versus the core competency of the courts. And where that line is, I don't know. I mean, at this point, of course, we're here to follow the law exactly. But let's say the law renders some results so completely horrific in content. How do courts address it? And how do we then tell people, come to us with your disputes? Come to us. We're here to resolve it because we're the ultimate dispute,
So that's the
resolvers.
follow, starting with you and then going to Judge Fisher, about public confidence in the...
Running short of time.
Okay, I'm sorry. Then I won't... It doesn't
Sorry.
matter then. Thank you.
No, it's okay. If you got time,
We like this
Well,
stuff.
public confidence in the courts is very important. That makes people accept decrees of the courts.
Absolutely.
Public confidence. The Chief Justice has talked about just two examples that I want to mention. These are nonpartisan examples. They weren't political at all, I don't think particularly. One of which was the possibility of making judges' terms slightly longer, not hugely longer, but it's not like the New York Supreme Court or something, like going to 8 years or something. And the second thing was, she's also suggested that we have a truly nonpartisan primary. I know there would not be party labels on the primary ballot. She wouldn't run on the primary. You'd run on the primary, but it would be kind of a free-for-all. Starting with you, Judge, do you have any opinion on either one of those two things about lengthening in terms of the judiciary? Because that way they are having to deal with campaigns and elections, and the possibility of eliminating partisan primaries in the judicial races.
I don't think lengthening the judicial would make a huge difference. I think we'd still have the same set of problems,
Okay.
right? The same set of problems is going to be how do we raise money, how do we get elected, so the key is the whole system has to look at it again through a more modern lens.
Right.
We have the fight over appointed judges versus the fight over elected judges, and that's been going on for years. We need a new model. What's a best practice? What's a sustainable model? Why aren't we looking at it? Why are we just trying to take what we have and stretch it? Let's look forward. We have the ability to now. I mean, with computers and data and everything else, to figure out what the sweet spot is. So that would be my position.
What about partisan versus nonpartisan primary?
I think it's very, very difficult to run partisan. I don't like particularly running partisan. Folks ask me all the time why I don't run independent or otherwise, and I say it takes too many signatures. So the way the signatures are when you run independent, I mean, I had to get 1,000 valid signatures. I think I had to get close to 4,000 valid signatures at 3,500 to run independent. So why do we have those bars against people running? I don't think we should.
I think we're the only state that has this particular setup. But
Yeah, that partisan in the primary and then nonpartisan in the general, correct.
Judge Fisher?
Yes. On the primaries, I don't care either way. People, because of the right of free speech and right of association, they're going to endorse people as they want. So whether that change, and it is the unique. I mean, I don't know if you saw in my handout, I had, for a while, I chaired the judicial selection committee for the bar. So I've thought about this. I don't know if I think maybe for the appellate courts or the Supreme Court, maybe a little bit longer. But more important to me than that is the statutes, that say you only have to be a lawyer for 6 years to be a judge. And you could run for the Chief Justice of the Supreme Court with 6 years of practice. And what if you have a great name? But you also have somebody with a not great name who's the Chief Justice and doing a great job. To me, but that goes to the legislature. The legislature would have to change that. To change the terms, you'd have to do a constitutional. Well, I take that back. You don't. The way the state constitution reads says for a minimum term of 6 years. The legislature, without constitutional amendment, could change it.
Oh, that's interesting, right?
I'm on that Constitutional Commission, and so we've been looking at that a little bit. And so the legislature actually could do it. We could ask for a constitutional amendment to mandate it. And I don't know if it makes a huge difference, but it might make a little bit, might take a little money out of the thing. So, but I think that qualification issue is much more important. Much more important.
Thank you.
Yeah, I really don't think the years matter. I would rather have somebody with the qualifications. So if you have somebody who's working as a fireman but has passed the bar 6 years ago, whether they working as a fireman and passed the bar 8 years ago, it's really not relevant. What we want to do is come up with minimum qualifications. 1 term as an appellate judge, or take the test, or so many cases in the court in which you're running. You're looking to put minimum competency of a quality that would ensure that you would have success in the position, not necessarily time or place.
And actually, if you read some of the comments to the chiefs, remember she put out her proposals, read some of the comments, there are several that we looked at about different, the word practicing law, what does that mean? Because then what if somebody had gotten her law degree and had been the ambassador to a country, and yet they weren't practicing. Trying to define that's hard, but I understand being something else. But so that's hard to define. But the idea of lengthening experience was overwhelmingly supported. Overwhelmingly.
Constitution is a lodestar and it's a centerboard. Did I get that right?
Yeah, one up, one down, one in the sky, one in the ocean.
I just want to just quickly follow up on. Did you say that you and your 2 brothers testified in 8th grade?
They were in high school. I was in eighth grade.
And what was the lawsuit?
It wasn't a lawsuit.
Oh.
My brother Joe got a ticket. I was driving with him on Route 8 down on the Kentucky side of the river, and we had turned onto Route 8 from a gravel road. And the back end fishtailed, and then he was fine. And we're going about 50 miles an hour. It's 2 lanes. And Sunday night, which down on Route 8 is very busy, and the police officer testified that he had crossed the yellow line in the jurisdiction 12 times. Well, my oldest brother John, he died recently, about a year ago. He was a big Democrat and plaintiff's lawyer, and he measured the distance from that street onto the Route 8, and the jurisdiction was only 1,000 feet. So how could he have crossed the line? And we would have been dead because there was all this. So Joe then testified. John testified 1,000 feet. I heard, because I wasn't in there, separation of witnesses. I'm out in the hallway. But Joe could listen because he was the defendant. So Joe testified he didn't cross the yellow line at all. And they called me, and I walk in, the big wooden doors, and I sat down, and they asked me questions. I loved it. And the judge asked me a couple questions, and he finally said, "Young man, how do you know your brother knew what he was doing? He was driving a car." I said, "Well, we were playing tough trivia." He goes, "What's that?" I asked him not who Lincoln's second vice president was, but Andrew Johnson. That's easy. Who was his first? And he answered Hannibal Hamlin of Maine, and that is correct. And the judge says, "Not guilty." And from then on, I wanted to be a lawyer.
But both of your brothers made the same determination.
Yeah, we had no college degrees till then, and all 3 of us went to law school. Very different. Plaintiff's lawyer, one from an insurance company, and me, kind of a bigger firm and then a judgeship. And my daughter, who at age 10, said that, I asked her, "You want to be a lawyer like your dad?" She said, "Do what you do, never." She's now an assistant prosecutor because after college she worked at the Rape Crisis Center. And she really wanted to become a prosecutor there. So out of no lawyers and all that to 4 of us. Anyway.
It's a dynasty. All right. Well, thank you.
Thank you.
Thank you.
We do ask
Thank you
if
very
you
much,
want to
everybody.
make a very brief, summing up statement just for about 3 minutes.
Okay.
I think since I started with Judge,
Okay.
we'll start with you, Judge Fischer.
I hope for your endorsement. I think my resume stands for itself. I think I've also shown that as a judge, not only high quality work and high quality effort, but that somebody who cares about the litigants and who, I tell you, in where I live, you don't win those 2 elections I won without support from independents and Democrats. And I think I reach out to everybody, and I get financial support and votes from everybody. And I think that's important because I'm perceived, I think property is fair. And I think, and I don't know if I put it in that materials or not, but when I was a little kid, I learned to listen. We had a big table, 9 people, and I was the second youngest, and my dad was a big supporter of the Democrats, and my mother was a big supporter of the Republicans, but they didn't care what I thought, because you're the youngest, right? And so I learned to listen and figure out what are good arguments and what are bad and things like that. And I think it's helped me greatly as a lawyer and wonderful as a judge. I'm not like Clarence Thomas. I don't ask a question every 10 years.
Oh, he's
But
changing.
yeah, he said. But I'm not an Antonin Scalia either. I don't ask questions constantly because I want to hear the lawyers' arguments because they actually know more about the case. Even though I've read the record and I've read the brief several times, but I was once called a lawyer's lawyer and once called a judge's judge, and my goal is to be a justice's justice, and I hope you can support that. Thank you.
Thank you very much for having this interview. It was very exciting and interesting, and the questions were great. And I think what I bring here is when I was younger, I grew up in a single-family household. My dad left our family as an alcoholic when I was 11. I have 4 younger sisters, and it taught me hard work. It taught me to be scrappy. My mom took a job at John Carroll University, and we all had to take a utility bill. So I've been employed since I was 13 years old. And my entire life I have dedicated to making sure the system works for everyone in the system, including those who have the least advantage. This was the case with me growing up, and I had to advocate for me and my sisters. In addition, I think you have 2 very good choices here. In fact, I think all of the Supreme Court candidates that are presently running are qualified judges on both Democrat and Republican side. But I think the thing that I have that's value added is I am looking for change. I am mindful of the future. I understand the changes and the paradigm that our information technology brings us, and I am forward looking. And I think we're going to need that because we're going to have 4 new seats on the Supreme Court, and that court will be completely turned over in the next 6 years. So I ask for your support. I've always been a people's lawyer and a people's judge. And I don't really represent corporations. I've always represented individuals one at a time. And that's what I bring to the bench, and that's what I bring to the judiciary. Thank you.
Thank you very much.
Thank you.
both.
Thank you.
I bet you I sounded really scratchy.
I wondered.
I was sick.
Thank you,
Thanks,
Judge,
sir.
for your time. Nice meeting you.
Nice meeting you.
Reminded me of that episode.
Thank you.
Oh, thank you.
Thank you
Judge.
for having us.
Thank you.
Yeah.
I'm sure that's really not, it's still going.
I liked what you guys have done to the building.
Yes.
Oh, yeah.
There's
Yeah.
lots of cool,
It is modern.
it is, it's very modern.
Lots of cool spaces.
And they pop the bones out of it. It used to kind of